Hello?
Mr. Stevens?
Yes, we got you that time.
Yeah, I could hear you. You couldn't hear me. I could hear you speaking. My name is I'm calling from Canada Revenue Agency. You had been trying to get me last week.
Yeah.
Regarding...
He's the one.
Yes. You left me a message to call you?
Yeah. We have an issue where my client, Mr. had gotten a form letter requesting a return, and we had called and spoken to one of your subordinates there, and that's how we got your name and number. We were requesting evidence that the acts applied to him and that there was jurisdiction over him. And honestly, she just didn't do a very good job. I know it was after lunch, and she just didn't seem to be on the ball. But she admitted that it was way beyond her, it was outside of her scope, and she wasn't, she couldn't give us any evidence at all to show that the acts and the laws applied and that there was jurisdiction over Mr. But she wouldn't back off, and she wouldn't stop the computer process and maybe, I guess, abate or vacate the account, which is why we were calling you.
Why wouldn't the acts apply to Mr.
Well, there's no evidence. There's no empirical proof that they do. And that's one thing, what we had gone through with the last woman that we had spoken to. So the question was if there was any empirical proof that the acts did apply, and she wasn't able to give us any. And another one was if there was any witnesses or personal first-hand knowledge that they did, and of course she wasn't able to either.
Well, sir, I can only say, in our position, we administer the law, we don't interpret the law, and we don't make the law. So in our administration of the law, Mr. is required to file a tax return.
Well, that's the prevailing opinion, but we don't believe that there's any evidence to back that up, that beyond your say-so that you have no actual proof to prove that.
Why? I just asked why he wouldn't have to file a return.
Well, that's the wrong question. The question is what evidence do you have that the acts apply and that there's jurisdiction and that he's required to file anything?
No, see, that's your question. My question is the opposite question: is why would he not have to?
Well, because the one who makes the accusation, which is with your agency, the one who makes the accusation bears the burden of proof. Now, we can still show that there's no evidence. We've spoken to one of your agents, and I'll ask you: do you have any empirical proof that the acts actually apply to him and that your agency has jurisdiction over him?
Well, as I said, Canadians are required to file tax returns.
Well, beyond your say-so, I'm asking for empirical proof of that. We've already gotten the opinions. We've got the political platitudes. All Canadians have to do X, Y, Z. We just want to know, and we don't see that there's any actual evidence to back that up. Well,
that's for the courts to decide, sir. So if you don't believe,
do you believe that there's evidence? Can confirm that there's empirical proof right now?
Well, under the Income Tax Act, he's required to, under Section 150, there's a requirement to file an income tax return.
Okay, but can you confirm at this point in time there's actually evidence to support that? Because if you let me just give you a kind of a preview. If you cannot confirm that there's evidence at this particular point in time, and you continue going after my client, when it does get to court, we will raise the issue of misconduct and gross dishonesty because you're knowingly bringing an issue against my client. Okay. You know that there's no evidence. So let's get on the same page here. Are you knowingly proceeding against my client without evidence?
We're not going to be on the same page.
Okay.
Your client is required to file a return. If we do go to court, then certainly that's something you can bring up, and it will be interpreted at that point in time.
Well, it's not a matter of interpretation. We want to know right now: can you confirm, yes or no, that there's empirical proof that the acts apply in this jurisdiction?
We are going by our policy and what we are required to administer, and that's what we administer, sir.
Okay, when you go by your policy,
the interpretation of the act.
No, not asking that. I never asked you to interpret the act. I'm asking for empirical proof it applies to Mr. in the first place. Two different things. So you need to stop conflating application with interpretation. Do you have any evidence, any empirical proof whatsoever that the acts actually apply to Mr.
Well, I at this point in time, I would have to look into the case further, sir. And I don't
Okay.
believe. Pardon?
I'm just writing it down. You say I at this time would have to. Okay, so that's reasonable. If you want to look into it and get back to me, that's certainly reasonable. And I'm
Sir,
glad to hear.
but I'm not in a position to determine that.
Well,
I can look into it, but I'm not in a position to make that determination at this point in time.
well, can you look? Are you able to look into whether there's empirical proof that the acts apply and that there's jurisdiction? I mean, certainly you're not going to proceed against Mr. without evidence of jurisdiction, right?
Is he a resident in Canada?
That's not the question. The question is, are you going to proceed
Well, why
against
are my
Mr.
questions not being answered?
Because I'm asking you a question, and then you want to just evade the answer to that question and deflect the attention away.
I'm asking a question for clarification.
Well, no, we have a letter that went through the mail, went to Mr.
Yes.
where you guys, someone down there has already made these determinations. I want to know if it's arbitrary or if it's based on facts. I am not going to fill in the gaps for you. I mean, I hate to be blunt with you, but I am not going to sit here on the phone and make a case against against someone I'm assisting. Do you or do you not have empirical proof that the acts apply to Mr.
Well, I'm not going to discuss those sort of things with you either, sir.
Oh, you're not going to discuss whether you have evidence or not. So
Well,
you're going to. You can look
Mm-hmm.
into it, but I'll tell you right now, I believe if you withhold what could be material evidence from us, I believe under Canadian law that's called perverting the course of justice. So I want to put
I
that
believe
up
that would
right
be
front.
in front of the court, sir.
Not
at this
necessarily,
time.
because if you
Well, you can argue what you want.
Well, no, I'm not trying to argue. I'm trying to just pin down whether you have empirical proof or not. But if you want to take some time and look at that, that's reasonable. But now but when you told me that before, you said you're not in a position to make a determination anyway. So I really don't understand.
Well, I'm not sure that I can even determine that, sir, at this point in time. I mean,
Okay.
I'll look into it, but I'm not sure that I can tell you yes or no one way or the other. I can tell you what it is I do, and
Okay.
I can tell you I'm certainly not a lawyer, and I'm certainly not those sort of things. So if you are asking for an interpretation that is legal, then I can't give you that.
I'm asking for empirical proof that the acts apply. Again, that has nothing to do with
I
interpretation.
understand your question.
And if you're not a lawyer and able to make these determinations, then you're really in no position to say that my client is required to file a return.
Well, that, as I said, if we go ahead, then that would be something that would be argued in front of the court.
Well, I want to be able to know before this goes forward. I want a yes or no answer, not an evasion. That I want you or someone down there to first confirm whether or not there's evidence or not. Because if you can't confirm there's evidence or not, then we've got a serious issue of bad faith where you're proceeding against Mr. without evidence of jurisdiction.
Well, and as I said, then Mr. would have an option at that point in time to appeal it.
Well, why should he have to do that if at this particular time... Well, let me finish. Why would he have to have this escalate when at this particular time, or maybe in a few days, neither you nor anyone else at the CRA can confirm that there's evidence of jurisdiction? Why not just drop it if you can't confirm that there's evidence of jurisdiction?
Well, as I said, that would be something that we would have to look into and see, and that would also be something you would have to, your client would have to potentially fight at the end. If we feel we have that, then that's how it would go.
If you feel that, and if you feel that you have evidence, then I would imagine that you can get beyond your feelings and you can actually demonstrate and present what that empirical proof is. And if you're not able to present empirical proof, then regardless of your feeling, I would hope that you would back off at least till such a time as you could prove jurisdiction.
Well, I will have to look into it and see.
Okay.
That's all I can tell you, sir.
All right. Well, we'll take it from there then.
Okay. Thank you.
All right. Thank you.
Bye.
Bye.